welcome to CUHK Law and the 2021 series of the Greater China Legal History Seminar Series. It's my pleasure today to introduce you to our speaker, Mr. Malcolm Merry. Malcolm arrived in Hong Kong 40 years ago and joined Hong Kong U in 1981. He rejoined the faculty in December 2006 after 17 years in full-time practice, in which he appeared or advised as counsel in numerous land-related cases. He served as a deputy district judge, presiding officer in the Lands Tribunal, and as a member of the Hong Kong Bar Council, the District Court Rules Committee, and subcommittees of the Hong Kong Law Reform Commission. In 2011, he was appointed head of the Department of Professional Legal Education at Hong Kong U, retiring in 2014, since when he's been an adjunct professor. He's also undertaken various other public service roles in Hong Kong as well, but he did ask me to keep the introduction very short, so let's keep it to that. I will mention that he has, I think last year, published a book called The Unruly New Territories, and I think he'll be mentioning that during his talk as well today. And I would recommend that book to you, pointing out, of course, that I get nothing from promoting this book, just that it is a great book if you're interested in new territories, if you're interested in custom and customary law and land law in the new territories, then a great book, and I recommend it to you. He also has a new project, I think, which perhaps he can talk to you about a little bit later on. Before we start, just to remind you, I'm sure you will have questions on the topics that Malcolm will be raising today. If you do, please use the chat function and chat them in, and I can ask them of Malcolm at the end. He's going to try and leave some time for some questions at the end of his talk. But now let me just launch the PowerPoint, and I can hand you over to Malcolm to give you his talk on the small house policy and updates on that today. Thank you very much, Malcolm. Over to you.
Thank you, Steve. Well, the topic today is the small house policy and the Court of Appeal, and I'll also be talking about Article 40 of the Basic Law. The case which triggers this talk is CUHK and the Director of Lands. I'm trying to get you the citation. There you are. CUHK and Director of Lands, Heng Yi-kuk, interested party, decided in January of this year. And the court, you can see there, reasons in January. It was argued in August, though, so it took 5 months for the decision to be published. It's a very long judgment, 138 paragraphs and 42 printed pages.
I'll just put it to the full page for you.
Yes, please. Ah, good. The decision was an appeal from Mr. Justice Anderson Chow of 8th of April 2019. This lecture is a supplement or update for my book published last year, particularly on Chapter 13, which concerns Article 40 of the Basic Law. If any of you are interested, incidentally, in the book, you can order it online, and there's a discount of 30%, which is down on the bottom left of your screen. I'm sorry, it may not be very readable, but I'll try and repeat it later. So this is Chapter 13 on Article 40. Sorry, Chapter 14 on Article 40. The main substantive issue in the case was this: whether on a proper construction of Article 40, ding rights are lawful traditional rights and interests of new territories' indigenous inhabitants in Article 40. Ding rights, as I'm sure many of you know, are housing privileges of what the court calls NTIIs, New Territories Indigenous inhabitants. And the ding grant is one type of small house grant. I want to emphasize that because we tend to use the small house policy as meaning the same as the housing privileges of the indigenous inhabitants. It's not, it's only part, the ding rights are only part of the small house policy. The small house policy is, of course, an administrative policy with small house instructions to civil servants. Small houses are technically new territories exempted houses. I'll come back to what that means. And small house grants are made by the government, including to new territories' indigenous inhabitants. So small house grants are not confined to ding. We're dealing, of course, today with Article 40, which reads, you can see at the top there, the lawful traditional rights and interests of the indigenous inhabitants of the quote unquote new territories shall be protected by the Hong Kong Special Administrative Region. Now, the Court of Appeal's decision, the court accepted the CUHK's argument that the traditional rights and interests in Article 40 simply indicate rights and interests enjoyed by indigenes at the time of enactment of the Basic Law. That's, of course, 1990. So what they're basically saying is that this phrase, lawful traditional rights and interests, is merely a label or description for all the ding rights which existed at the time of the Basic Law, as a matter of historical fact. Now, how did the court reach that conclusion? Their approach, they reached it as a matter of interpretation of the Basic Law. Simply of interpretation, at least that's how they presented it, applying in particular the continuity principle and the coherence principle, two principles, of course, which have been laid down by the Court of Final Appeal for interpretation of the Basic Law. And they wanted to have a contextual and purposive approach to construction as at 1990. What's the context? According to the Court of Appeal, the context is other Basic Law provisions, the Sino-British Joint Declaration, pre-enactment and contemporaneous materials, such as the Basic Law Drafting Committee documents and the Consultative Committee documents, and the state of legislation at the time of the Basic Law. But also, they said the context was historical, the history was relevant. And indeed, they spent a long time considering the history, the background to it. So the Court of Appeal embarked on a survey of events regarding New Territories land going back to the Second Convention of Peking, so-called New Territories Lease of 1898. Now, why did they say this was part of the context? Well, because the Basic Law, Article 40, concerns traditional rights and interests. And they said, of course, tradition has its origin in the past. I find that rather a strained interpretation of context, that you have to go back 90 years for the start of the context of a 1990 provision. And indeed, if you think about it, traditional rights and interests is content. It is not context. Anyway, they had a nice excuse for a historical survey, and the historical survey takes up 40%, no less, of the judgment. Consequently, I feel justified in talking at length about the historical side of it, this historical survey. Now, unfortunately, unpromisingly, their survey starts with two mistakes, two inaccuracies. First, they said the concept of an inhabitant of Hong Kong as a new territory's indigenous inhabitant only came into existence in 1898. Well, it didn't. That phrase, indigenous inhabitants, came with the small house policy in 1972. And before that, in the 1950s particularly, a variety of terms was used for what is now called indigenous inhabitants: genuine new territories resident, bona fide villagers, smallholders, farmers, poor men, peasants, new territories men, little men, natives. You'll find all these in the government memos during the 1950s. Indigenous was occasionally used, but not indigenous inhabitant, indigenous native, indigenous population, and grantees of old schedule lots. These are all used by civil servants in the 1950s and 60s to describe the beneficiaries of ding rights. Of course, the Court of Appeal meant that the new territories started in 1898, well, actually 1899, when the British took over, because it was a colonial concept. That's true. Compared with the rest of the colony, they said, which was ceded to the British government under the Treaty of Nanking of 1842, the leased territory was new from the perspective of the British administration. Well, yes, but it wasn't the Treaty of Nanking that ceded the rest of the territory. As every Hong Kong law student knows, Hong Kong Island and South Kowloon was acquired in two stages under different treaties. Treaty of Nanking was one of 1842. That was for the island of Hong Kong. But the rest, the southern portion of Kowloon and Stonecutters Island were under the Convention of Peking of 1860, which the Court of Appeal omits from its consideration. Now, the internal government source documents for this historical survey, which were used by the Court of Appeal, began in 1957. This is because they relied on a New Territories Administration internal government paper, which dealt with the history starting in 1957. This is the document, the New Territories Small House Policy, published in February of 1980, the author of which was Mr. Joseph Lam Ding Kwok, Chief Land Executive. And Mr. Kwok consulted colleagues in the administration who dealt with New Territories matters, including Mr. John Davison, a solicitor then in the New Territories Administration, who happened to give expert evidence at the trial of the Kwok case. This 1980s paper mentions Ding custom at the beginning in one sentence, and its description of that Ding custom is incomplete. And it says that the tradition was officially endorsed by the Executive Council in October 1959. Now that is, unfortunately, another inaccuracy. That's an exaggeration, if not a misinterpretation of what happened. Yet it was accepted, it was just repeated by the Court of Appeal. A better starting point, in my opinion, for any historical survey would have been 1949. 1949, Hong Kong was making a swift recovery from World War II. There had been a big influx of people from China, including into the New Territories, and the growth in manufacturing was phenomenal. There's a sort of industrial revolution taking place, and the Chinese Civil War created a big demand for goods made in Hong Kong. There was inflation of rents and prices and a shortage of housing. So there was pressure on the whole colony, but of course, the space was in the New Territories. So on the periphery of the New Territories, there was urbanization going on. This is a map of Hong Kong in the 1950s. I don't suppose you can see very much, but you can see the dark areas of the urban parts, and they don't spread very far to the north, but they were going on up above Kowloon into the new territories, into Kwai Chung, Lai Chi Kok, and Chun Wan. These were sites, places where factories were going up, but also in the old new territories towns, they were expanding too. Tai Po, Chun Mun, Yuen Long, Shang Shui Fan Ling, these places were all urbanizing slowly, and therefore they were the subject of land speculation. Now, the district commissioner in 1949 for the new territories, the man in charge of the administration, was a man called John Barrow. He's in charge of the new territories, and he was having to deal with many applications for what was called conversion of land. This means permission to change the use of land from agriculture to building status. A lot of applications from entrepreneurs who wanted to build factories, shops, houses, and courts. And the land was governed, most of the land was governed by the block crown leases, which had been granted in 1905 and 1907, which contained a condition or covenant against building. You had to apply to the government if you wanted that lifted. There's a similar condition in urban crown leases, and the government policy was to charge for that permission. They charged a premium based on the full improved value of the land. So the practice in the new territories was, before the war, to charge for premium on building land, which was granted after 1901, the so-called new grants, but not on the so-called old schedule lots. Old schedule lots were lots which were governed by the crown lease, the block crown leases. So Mr. Barrow was faced with applications to build on the old scheduled land from purchasers from farmers. They were not the original owners. They were businessmen who wanted to erect commercial premises, especially in and near those developing new towns and the spreading urban area. He had, for instance, Shanghai manufacturers who'd moved to Hong Kong who wished to put up factories or wished to have luxury houses with gardens in the new territories. He had to deal also with wealthy townies who wanted to have large country retreats in the new territories. So he said, I don't see why these people, just because they bought up old scheduled land, should not have to pay a premium. But he was also getting applications from indigenes who wanted to build larger residences, not small houses, but garden houses in the villages. And he said, well, they too should pay a premium. Consequently, Barrow initiated a debate within the government, starting in January 1949, about land policy in the new territories. And that debate lasted for more than a decade. Sorry about this, it didn't come out as I intended. That is an extract from his minute, which he made in January 1949. But this wasn't mentioned by the Court of Appeal. Let's go back to the map. This wasn't mentioned by the Court of Appeal because they started with the 1957 EXCO decision. So Barrow said, well, I've got no intention of changing the practice that we don't charge a countryman premium for building a simple peasant house on his land. But this was regarded by him as a concession. It was not regarded by him as an indigenous right. It wasn't confined to indigenes. It was confined to villagers. including indigenes, and all countrymen were entitled, in his view, to a simple peasant house. And by 1949, there were two generations of immigrants into the new territories, and indigenes were actually the minority. He asked his colleagues for help, and one was the land officer. He's a solicitor in the Registrar General's Department called Honoran Jones. And he went back. He found that many of the pre-war records had been lost. Barrow couldn't find records. Jones found a few old land records. And he said it does seem that there was in practice a concession to the country people, but it was confined to small holdings in undeveloped areas and subject to safeguards against abuse, against reselling at a profit, for instance. And Jones suggested that the policy that they were going to hammer out should be based on three motivations. First, concern for poor country people. Second, encouragement of rural development. And third, the desire to safeguard public revenues, to pay for services, what we today would call infrastructure. In other words, these were the bounds of the concession. These limited the concession to the country people. And it's interesting to note that honouring tradition, preserving custom was not a motivation for these civil servants in 1949. Barrow received approval from the Colonial Secretariat, the headquarters of the administration on Hong Kong Island, permission to charge for urban and suburban developments in the new territories on the 7th of July, 1949. But presciently he said, I expect opposition from rich men in the new territories. And a petition from the CUHK duly arrived in November 1949. And that is part of that petition. Again, I apologize for my technical skills not being up to reproducing it. But what they said in their petition, CUHK said, was that Governor Clementi in 1926 had promised that premia on old schedule lots would be abolished. This is Cecil Clementi in his governor's garb. In the middle, by mistake, is a picture of John Barrow in white. It looks as if he's being cradled by Governor Clementi. So Clementi was cited by the CUHK, and they argued that the new territories lease forbade premia to be charged. I think they were relying on the lease saying there would be no expropriation of natives. So the CUHK regarded charging them for building as taking away part of their property rights. And they also quoted something they called the New Territories Ownership Ordinance, Section 4. There's no such ordinance at all, but they argued there was a right under that. Now, this was to become a familiar refrain. The administration looked into the allegations by the CUHK in their petition. They could find no record of Clementi's promise. The records had all been destroyed. However, Barrow replied to the CUHK. He said, got no intention of charging a conversion premium on scheduled lots owned by genuine New Territories villages where the building is an extension of an existing village or will be an isolated house on agricultural land near the village. So he tried to reassure them. That didn't satisfy the CUHK. Why? Well, because the council of the CUHK was dominated by New Territories businessmen, by investors, not by genuine villagers or poor peasants. It's worth remembering that the CUHK had started in the mid-1920s as a commercial as well as an agricultural organization. And that's how it came to be dominated by indigenes who had branched out into business. In August of 1950, there was another petition by the CUHK asking that the new policy be revoked and claiming all villagers are very dissatisfied. The following month, Mr. Jones, the land officer, he'd searched the files again. He could find no trace of Governor Clementi's decision or promise, but he could find suggestions that no premium would be charged for what he called land court judgments, or land court judgment lots. That's to say old schedule leases, pre-1898 landholders leases. But Jones went on, he said, times have changed. There's now a lot of speculation in New Territories land. I think the original intention was to permit a genuine New Territories resident to build for himself and his family on his native ground, and we should stick to that. The administration's internal reaction in the minutes was dismissive. The civil servants thought the Hongi Cook's case was poor, that they were making a mountain out of a molehill, and that New Territories people would be hardly affected by the policy. What they meant by that was genuine villagers, because all the conversions were in urban or suburban areas where they charged premium for giving building permission. So in October of 1950, Mr. Todd, the Colonial Secretary, responded to the Hongi Cook's petitions and told them it's only urban and suburban developments, which are very different from the rural development of Governor Clementi's day. The reason for charging premium is because we have to pay the cost of public amenities when there's development, and we've got no intention of charging a smallholder who builds a simple house on his land. So the upshot of all this was that houses on new grant land, post-1900 land, which had been bought at auction, would have to pay a premium. So would houses on suburban or urban sites of developments, but not houses for village type development, village type houses, which genuine villagers owned. And the administrators set about drafting a set of principles to reflect that approach. It proved to be surprisingly difficult with such a variety of circumstances, and they wanted to keep things flexible, and they couldn't decide on the basis for charging the various premium. However, they were certainly of the view that village houses in rural areas would be unaffected. We entered then a quiet period, 1951 to 1955. Not much happened. And then at the end of 1954, there was a new district commissioner for the New Territories called Kenneth Barnett. He's a very interesting man. He's quite different from his predecessors. He was a classicist and an academic, precise-minded man, a bit of an eccentric, large chap with small, neat handwriting. He was a bit of a gossip and a raconteur as well. And he was multilingual. He was fluent in Cantonese, written and spoken Chinese. He was interested in Chinese culture, and he was protective of and sympathetic to villagers. Although interestingly, he was disdainful of the Cook's leaders, who tended to come and lobby him and give him different versions of what was happening within the Cook. He was, to my mind, a prime example of what might be called the romantic district officer who was struck by the traditions in the New Territories. And in March 1955, he told his superiors that New Territories people do not hold the view that the increment in value resulting from conversion of agricultural land to building land belongs to the government. So his superiors, perhaps a bit surprised about this, they instructed him to give his views in writing and provide a history of New Territories land policy. On the 19th of January 1956, there was a meeting at Government House of all the senior administrative officials, including the governor. That's Sir Alexander Grantham. Sir Alexander Grantham is the bald chap in the middle of this slide, and he's visiting in the 1950s, he's visiting the CUHK. And to his left, and the right in the photograph, is Sir David Trench, who's another future governor of Hong Kong, who was then the Colonial Secretary. Anyway, they had this meeting, and as I say, all the big noises were there, and Barnett proposed to them that the interests of the indigenous population should be taken into account, should be part of the policy. But his suggestion was rejected. There's Alexander on the outside of Government House in the 1950s. He was quite adamant. So Alexander was quite adamant. He said government policy was to protect and develop the colony according to the several needs of its inhabitants and the interests of the colony as a whole. So he was not going to have any of this indigenous rights business. So much for indigenous rights and interests in 1956. Court of Appeal, of course, didn't mention any of this. Perhaps they didn't know about it because they relied on the evidence that was put before them by the parties. And there's a volume of evidence, of course, from the government, but I don't know whether it covered these events. By May of 1956, Barnett was reporting that the CUHK was hot under the collar and that he, Barnett, expected another petition. That duly arrived in May of 1956, and that's all I could get out of it, I'm sorry to say, so we won't dwell on that. The petition argued similar points to those in the earlier petitions, but in more detail. First, they relied on the 1898 treaty, the lease, the Second Convention of Peking, particularly on this bit. It's further understood that there will be no expropriation or expulsion of inhabitants, and that if any land is required for public offices, fortifications, or the like official purposes, it shall be bought at a fair price. Further, they relied on Governor Blake's promise. There's Blake, his proclamations at the turn of the 20th century, 1899, when Britain took over. He told them, amongst other things, your landed interests will be safeguarded and your usages and good customs will not in any way be interfered with. They, the CUHK, also relied on this legislation that nobody could find, and on a 1906 decision by Governor Nathan not to charge premium on old scheduled land. Nathan thought, well, these people were there when we took over. I don't think it would be right for us to charge them for developing their own land. So the CUHK argued that for decades, no premium had been charged for building permission. Only an increase in rent had been charged. And it seems they were right about that. But the reason they'd not been charged was not so clear. Unexpectedly, recently, they said premium has been imposed. They were complaining about it. In July, 3rd of July 1956, Barnett's long-awaited memorandum on land policy landed on the desks of his superiors. It was also a reaction to the CUHK's petitions. Now, this memorandum, the Barnett Memorandum of 1956, was relied upon both by the trial judge, Mr. Justice Chow, and the Court of Appeal. But they don't give the background to it. They just rely on this, and you'll see why. Because the 5 needs were spelt out by Barnett. He said there are 5 needs which have motivated policy. The first is the need for control. In other words, government planning and administration, health and safety, and so on. Very important. Second is the financing of public services. And third, the honouring of our undertakings to the country people, whatever that meant. Notice country people, not just indigenous people. Fourth, encouragement of development in suitable areas. And last, the taxing or confiscating of surplus value of developed land. In other words, take away the increase in value which had been given by permission to build, the betterment value as it's sometimes called. So those are the 5 motivations, one of which, only one of which, is the honouring of undertakings to the country people. But the Court of Appeal got their highlighter pen out, in effect, and emphasised the third of these considerations. To be fair, Barnett went on to say that the privileges accorded to successors in title by descent from those who were awarded land by the land court at the turn of the 20th century, in other words, old schedule lots, those who were in possession of old schedule land in 1900, they should be maintained, and that we have said many times that the grantees of old schedule lots and their descendants are not required to pay premium for conversion to build traditional village houses for their own occupation. And he added, they're in effect entrenched, it would be dangerous to deny them. So that was his view. There's no mention by him of new grant land, post-1899 land, because obviously the custom could not have applied to it. Now, this long memorandum by Barnett was later attached to an Executive Council memorandum, which asked them to change policy. And that's why, because it was brought to the attention of EXCO, why it was also brought to the attention of the Court of Appeal judges. However, but note the following: honouring the undertakings of the country people, whatever that means, is only one of 5 policy considerations. Modern considerations of planning, development, administrative control, finance, together must have greater weight. There's no mention of custom. Instead, there's a reference to privilege. Privilege accorded by administrative practice. Promises made. Possibly because the administration thought that the Block Crown leases were not legally binding. I'll come back to that. Limitations to the privilege. Only indigenes could have it. It applied only to their own land. It applied only to traditional village houses, or as the administrators called them, VTHs, village type houses. and only for their own occupation. And even Barnett said that the pre-1899 events relied upon by the CUHK were irrelevancies. And Barnett's view was not shared, I should add, by all his colleagues. So even Barnett went on to emphasize the government need for control over development and the need to pay for public works. And he said that the old material relied on by the CUHK were irrelevancies. In other words, there was no right from custom to special treatment. It was an administrative indulgence. But that part of his memo was not quoted by the Court of Appeal. His colleagues were even more disdainful of the Hung Ye Cook's old arguments from history. The acting Colonial Secretary, Claude Burgess, said the petition's hopelessly obscure. And the Attorney General advised that nothing in the 1898 convention prevented us from charging premium on conversion of agricultural land. So he obviously did not regard that as expropriation of rights. The land officer, Mr. Jones, was less certain. He said, I've hunted down the texts which are referred to by the CUHK, but he said, well, they're not really relevant. Everything was replaced by the Block Crown leases in 1905, which contained building restrictions. But I am a bit concerned that the Block Crown leases might not be binding because they hadn't been signed by the grantees. They were signed by Nathan, the governor, and Lugard in 1907 as well, but they might not be binding because the grantees hadn't actually signed them themselves. I think he was wrong about that, but there we are. He was worried. And he said also the convention, that's the 1898 treaty, and the proclamations of Blake might mean that the Block Crown leases are ultra vires as well. So there were those concerns privately expressed by the land officer. He was wrong about the second one as well, as we know, but there's no time to go into that. Meantime, the Hung Ye Cook had become riven by factionalism and backbiting. It had had acrimonious, noisy, and inconclusive meetings, according to the government memos. There were hardliners who wanted to pay no premium for any land, on any land in the new territories, particularly, of course, development land on old schedule lease land, even in urbanizing areas, even for factories, hotels, and shops. The more moderate faction were willing to concede to pay a low premium on such land. But they said, we're not prepared to discuss this anymore with the district commissioner. We want to see the governor. Not surprisingly, official memos recorded that the CUHK had dissolved into chaos and brought itself into contempt. The hardliners took over. In December of 1956, they wrote a letter, which I'll try to reproduce here without success. Their letter said that customarily there was never any distinction between agricultural and building land, that the government was violating the 1898 treaty, that the government doesn't care about New Territories inhabitants, and that New Territories public opinion was on the CUHK's side. Notice there that I think they're referring to New Territories public as meaning the indigenous people, the minority now in the New Territories, in fact. The official reaction to this letter was that it was irresponsible and stupid, and also that they suspected that communists were fomenting trouble within the CUHK. Barnett said But to claim there was no distinction between building and agricultural land was nonsense. So apparently even he didn't accept their appeal to custom and tradition. In other words, their argument that Governor Nathan, there he was, had in fact disallowed the charging of any premium. As far as the government was concerned, land law in the new territories began with the Brock Crown leases in 1905. And those leases made a distinction between agricultural and building land. That's why they were so, government was so dismissive of the CUHK's claim. There were special rules for village type houses on old schedule land, yes, but they were an administrative concession, not a legal entitlement in the eyes of the administrators. There is a block crown lease. I should explain to the uninitiated that this is why we call them old schedule land. The block crown leases had attached to them schedules of all the lots that were governed by the block, by the area, governed by the printed lease. This, as you can see, was filled in by hand. So these were old schedule. These were records of landowners, people found to be landowners during the Great Survey of the New Territories between 1899 and 1903. They were all recorded and then attached to the appropriate Crown lease. So this is old schedule land. The CUHK and the government were talking past each other here. The CUHK was talking about pre-1898 matters, what happened in the old days under custom, under tradition. Of course, the government, Barnett included, were talking about what happened after we took over in 1899. That's why they said there was never any distinction between agricultural and building land. That's nonsense. But the CUHK was saying traditionally there was. Well, eventually there was another meeting of top officials. It was agreed by them, not surprisingly, that there was no legal obstacle to imposing terms for conversion of agricultural land, and that free conversion was to continue for genuine village type houses, but not just in rural and undeveloped areas. The CUHK chairman, Mr. Ho, requested a meeting with the governor. He didn't get it. He got a starchy letter from the Colonial secretary, Mr. David, who said it's difficult to accept your claims as serious. You must know that a distinction has always been drawn between agricultural and building land. In other words, in the block crown leases. There's no point in meeting the governor. We will formulate the policy ourselves without delay. So a paper was prepared for the Executive Council, that paper to which the Barnett memo was attached. And on the 9th of April 1957, the Executive Council approved the proposals. But their approval, the new policy, was not announced to the public. It was a secret policy, an internal policy. The EXCO paper is mentioned by the Court of Appeal. The practice regarding the old schedule lots was mentioned. That is to say, the bona fide villager will in general be permitted, subject to planning and feng shui considerations, to build a village type house for his own occupation, free of premium. That was the focus, of course, for the Court of Appeal, but there was all this other stuff surrounding it. Note, though, the 4 qualifications that they had in that paper for the EXCO, and also the qualification in general. So the Executive Council was maintaining a discretion for the administration to refuse even bona fide villagers permission to develop houses on their own land. So this was hardly a recognition of a right, which is how it's presented by the Court of Appeal. In August of 1957, the government withdrew recognition of the CUHK after hardliners were elected to the committee in a fixed election. And eventually the government took over the premises of the CUHK. In 1958, a new man was in charge of the new territories in succession to Barnett. The new man was Mr. Holmes. So there's the block crown lease condition I mentioned, not to convert any ground hereby expressed to be demised as agricultural ground for interuse for building purposes without the previous license of his said majesty signified in writing by the governor or other person duly authorised. The other person duly authorised was invariably the district officer. So those were the qualifications I've just mentioned behind the approval by EXCO in 1957 to the new practice. But there is Ronald Holmes. Now, Holmes was quite a contrast to his predecessor. He was a hard-headed, no-nonsense administrator, been in the military and in the spying game during the Second World War, and he was regarded as a troubleshooter by the administration. He had been in charge of resettlement in the early and mid-1950s. So he was parachuted into the New Territories Administration because it was perceived to be in trouble. It was overwhelmed by work. One of the first things that Holmes had to face was another petition, yet another petition from the CUHK. Familiar arguments. Sorry, this is my attempt to have another photograph of Mr. Holmes. He would have been on the right if it had come out properly. Yet another petition. You have to turn your head sideways for this one. I'll tell you it's not worth it because it's the same arguments all over again, relying on the Convention of 1898, Blake's Proclamation, custom and so forth, but adding there's an urgent need of housing in the new territories. But the government had withdrawn recognition. That's what they were arguing. The government had withdrawn recognition from the CUHK, so Holmes said, ignore them, ignore them. I'm working on new policy proposals, especially regarding the development of old schedule lots. And in he composed a memo, and that's part of the memo. Again, sorry about that, but what he said was that there are difficulties with the existing rule. The difficulties are that bona fide villages are impossible to identify. Do they include recent residents? Do they include residents of new villages? Do they exclude rich people? Also, there are difficulties with village type houses. What's a village type house? They have to be hovels, they have to be built of poor materials, they have to have slit windows, they have to have the kitchen near the front door, they have to have no lavatories, and so on. So he said, let's do away with all these conditions, all these qualifications. I propose a new rule. We will allow any owner of an old schedule lot to build free of premium a small house. So this is where the phrase small houses starts in 1959. And he defined a small house as a single story structure, maximum height 15 feet, domestic dwelling occupying no more than 700 square feet, but could be erected only subject to planning and feng shui considerations and in exchange for an increase in Crown rent. There was no requirement in his eyes for the beneficiaries to be, the grantees to be indigenous. There was no mention of custom. But he said it's still going to be possible for a bona fide villager to build a village type house up to 700 square feet in height, 700 square feet in size. That will, he said, that will enable farmers to replace their wooden sheds with permanent and more hygienic buildings. He described them as bungalows. So his aim was not to preserve or recognize Ding rights, but to improve housing for all New Territories' rural inhabitants. And remember that in the 1950s, there'd been a big influx of so-called squatters, of immigrants who were living in flimsy structures made of so-called temporary materials around the villages in the rural areas. This important memo of Holmes was not mentioned by the Court of Appeal or by the first instance judge, presumably because it wasn't included in the evidence by the government. The Colonial Secretariat raised questions about Holmes' proposal. And these questions were dealt with by Holmes' then deputy, Dennis Bray, who went on to be the sponsor of the small house policy 10 years later, 13 years later. And the Secretariat was concerned that this new rule of Holmes's would allow urbanites to set up weekend bungalows on old scheduled lots. And Bray and Holmes replied, they said, well, there's nothing much to stop that now, actually, because an urbanite can simply recruit a villager to put up a house and then sell it to him, the urbanite. There are no restrictions on alienation. But they made a prediction, a fatal prediction. This won't lead to mushroom growth of such houses, they said. The proposal was accordingly approved by the Colonial Secretary in June 1959, though there was the qualification that the situation should be closely controlled and reviewed. In November of 1959, Holmes minuted that two principles were paramount. This is where this slide comes in. First of all, no concessions should be made to indigenous natives as such, indigenous natives or bona fide villagers or block crown lessees. Lessees on old schedule land should be treated as in a contractual relationship with the Crown in every sense comparable to that of Crown lessees of new grant lots. No distinction between the old land and the newer. So every New Territory landowner was to be treated equally. But then he added, by all means, make concessions to the poor man or the lessee of agricultural land. So again, he was saying, we'll make concessions, grace and favor concessions to these people, but they have no entitlement to it. Now, these principles form the basis, or part of the basis, of a policy paper presented to EXCO in October of 1959. Now, this policy paper is quoted by the Court of Appeal. The new policy was approved, and it included this: we can make concessions to the poor man or the lessee of agricultural land, highlighted naturally by the courts, but they don't really mention the context, which puts quite a different complexion on it. It puts quite a different complexion on the assertion by the Court of Appeal, echoing that 1980s New Territories Administration paper on the small house policy, that ding custom was, quote, recognised, unquote, by the Executive Council. Now that word recognised was used by Mr. Lamb in his paper in 1980. It was not in the 1950s papers at all. And that word recognised suggests it was approved that there should be some concession to tradition, and that was a motivation for the policy. And it just wasn't so. If you look at what the administrators were saying behind the scenes. So in reality, the New Territories Administration were making policies which regarded the pre-1898 practices as irrelevant and allowing countrymen, not just dings, to build on their own land, premium-free, as a matter of concession, and for a variety of reasons for which custom or tradition was only one. And that the CUHK's arguments based on custom were regarded as irresponsible and opportunistic and selfish even by the leaders of the CUHK. And in November 1959, the government took over the CUHK's offices in Taipo and dissolved the organisation, preparatory to putting it on a statutory basis. In April 1960, Mr. Holmes's successor, Arthur Walton, followed up on Holmes's theme of abolishing the distinction between old schedule land and new grants. Walton proposed that holders of pre-war new grants should be allowed premium-free conversion too. He minuted, that's his minute, he minuted the idea that holders of old schedule lots are specially privileged should disappear. The distinction between old schedule lots and pre-war new grants should disappear. Post-war new grants, he said, are different because they've been the subject of purchase by speculators. But pre-war grants, we can allow them to have premium-free conversion. Again, no mention by him of custom. I should add that the Registrar General, Mr. Thompson, was a bit wary of this proposal to allow pre-war new grants, premium-free conversion. He said, well, that's a major concession. We're giving up money, income from the government. We better refer it to EXCO. Walton wasn't happy about that. In June 1960, he minuted the Deputy Colonial Secretary saying since 1902, the idea has persisted in the New Territory that holders of old schedule lots are specially privileged. They claim there were no restrictions under China. It's desirable that this idea should disappear. Government should stand firm on the principle that all private owners in the New Territories hold on lease from the Crown and are bound by its terms. Though premium is in fact never charged, there's nothing in the Rock Crown leases prevent us from doing so, nor are we obliged to give permission to build. We have a discretion. In June 1960, an extension of pre-war grants, new grants, an extension of the privilege to pre-war new grants was approved by the Executive Council for village-type small houses for their own occupation. Larger houses, even larger houses built by indigenes, had to pay a premium. And Walton informed the rural committees of this, and it was the first time that this new government policy had been revealed to the public. Sorry, jumping ahead. So this extension to new grants was presented by Mr. Joseph Lamb in that 1980 paper as evidence of acceptance of the custom of the indigenous. On the contrary, Walton and Holmes saw the extension as eliminating an unfair distinction between the various types of landholders in the new territory and as denying any privilege based on custom. Nevertheless, the Court of Appeal said it's abundantly clear. Pause here to observe that wherever a judge, or indeed any lawyer, says something is abundantly clear, you know that what is about to follow is not clear at all. They are asserting because they're uncertain. They said it's abundantly clear that the custom was officially endorsed in 1959, Court of Appeal and Mr. Joseph Lamb. I say no. Even Barnett recognized and partly relied, though Barnett recognized and partly relied on the custom, his seniors and successors did not. And it's contradicted, what they say is contradicted by contemporaneous documents from senior officials, not cited by, and perhaps not cited to, the Court of Appeal. The Court of Appeal also relied on a 1967 EXCO memorandum where somebody in the government had claimed that there was a tacit agreement that since the beginning of the new territory's lease, in other words, 1898, there has been a tacit agreement that the villagers be allowed to build houses for their own occupation on their own agricultural land, held under block crown lease, free of premium. Now, this is a most unfortunate phrase, in my opinion, because it's inaccurate. There was never any such agreement. There was more likely an agreement to disagree about the basis on which any premium was charged, or was not charged, I should say. As far as the cook was concerned, the entitlement was based on custom and promises, as we've seen. But as far as the government was concerned, it was merely a pragmatic concession and subject to strict limitations. The only common ground between them was that there would be no premium charged to the old schedule lot holders, the original ones. Now, the origin of this tacit agreement phrase was in a memorandum, I think, from the New Territories Administration to the Director of Audit, explaining why there was no government income from the grant of licenses to build on old schedule lots. They were saying, well, we don't charge because there's a tacit agreement that we don't. What the writer was trying to convey was that there was this agreement to disagree. And although the cook asserted a right to build, the government didn't accept that, but said that its permission was needed and it could charge, but as a matter of concession, it wouldn't. No entitlement in government eyes. Well, that was 1967. As we all know, the small house policy came in 1972, and the Court of Appeal said that the policy elevated practices regarding the small house grant into a formal government policy. Well, there again, I have to demur from that statement by the Court of Appeal. As we've seen, there was, excuse me, a formal government policy, and it had been in place since 1959. that policy was incorporated into the small house policy and was expanded, not elevated. The main substantive innovation with regard to indigenous grants was the systematic provision of building land through private treaty grants. That was a political decision in 1972 in response to unrelenting unequal pressure for more land because of they alleged a shortage of sites. That shortage of sites was not encountered in 1898. Yet the Court of Appeal presents this the small house policy as itself a recognition of custom. I want to turn now to the question of private treaty grants, or PTGs, because it's the area where the Court of Appeal differed from the first instance judge. Mr. Justice Chow, as you remember, concluded that PTGs were reintroduced by the small house policy and were not customary or traditional. Court of Appeal concluded that they were. It in effect accepted the CUHK and the government's case. Their reasoning for doing so was somewhat tortuous. So they said they were reinstituted by the policy in 1972 and that they were traditional. Now, the Court of Appeal's reasoning requires us to accept three things. First, that the practice of elders approving house construction before 1899 was the equivalent of the government granting discounted building land by private grant post 1972. That cessation of private treaty grants for two periods, quite extended periods, during the 20th century is irrelevant. In other words, there was a continuous practice. And third, that restrictive village auction is a private treaty grant in disguise. Now, I would take exception to all three of these. I think that each of them is dubious. Was the pre-1899 practice a private treaty grant, a private grant? I think this is it was probably suggested that it was by the government's expert, Dr. Hayes. Now, the practice, pre-1899 practice, was described in the Winfat case by Mr. Justice Kempster at first instance, and also in the Privy Council by Lord Diplock. And it was to the effect that if a villager wished to build, sorry about the typo, to build for himself or his son, he would apply to elders, village elders, for permission. And the elders set rules as to whether, how, and where the house might be built. This is my summary. Now, the village elders made important community decisions, including regarding houses. And so that's why the villager had to apply to the elders for permission. And they could accept or reject the application. But there were differences between this traditional practice and the previous practice in the 19th century. The first, it seems to me, is that the elders did not supply land. The elders had to approve the building, yes, but the villager had to acquire the land. He did it by purchase, by inheritance, or by long cultivation. But he had no right to build on other land, other people's land. With the private treaty grant, the government uses government land or resumes private land and turns it into crown or government land near the village and then sells it at a discount to the applicant in indigene. The government, not the villager, therefore selects the site. So this is another difference. And the government says there's a requirement for an orderly layout of the village, planning in other words. The elders only had a power of veto. Also, more fundamentally, it seems to me the elders were internal village authority. The external authority, though an ineffective one, was the imperial magistrate. And the imperial magistrate was the equivalent of the modern district land officer. And they are external authorities. The post-1898 internal authority was at first the so-called committeemen appointed to advise the district officer. They were often elders, of course, themselves, and later village representatives. The customary right was a right to build on your own land in your own village, a small house, or your own home anyway, a small house for yourself or your son upon marriage. Well, the upon marriage is disputed, that's what the government says. So you needed land before you could build. There was no right to build in the abstract. Applicants to the elders already had land, or at least the prospect of it. Applicants for private treaty grants, by definition, did not yet have land. And to say that a private treaty grant is to enable indigenes to exercise the right to build, in my opinion, has matters back to front or upside down. There was no right to build without land. The provision of land so that you could exercise your right, your so-called right, in 1972 was a real innovation by the small house policy. That was the provision of land at below market price. And that was a further innovation. There's no suggestion that I can see that pre-1899 that the indigene would have had to pay a below market price. He would have had to pay whatever was demanded by negotiation. There was no entitlement to a discount. None is mentioned by the Court of Appeal. Also, the imposition by the authorities post-1899 of conditions of grant, including the obligation to obtain permission to build, was something new. It was not a right, but in fact, more like a duty, because once you had a private treaty grant, built into the conditions of grant or the conditions of sale was an obligation to build within a certain period, 2 or 3 years. And also there was initially at least a restriction on the grantee's power of alienation. So it's somewhat strange to call this a right. The timeline for private grants, this is broadly what happened over the years between the British takeover and the small house policy. From 1899 onwards, there was sale by public auction. Then in 1909, private treaty grants were permitted because the government was having difficulty selling land in the new territories, particularly in the remoter areas. And they said, well, why can't we just directly sell to, there's only one person interested in these areas, that's the person who wants to buy land. But in the 1920s and the 1930s, there was poor demand for land in the new territories because of the conditions. There was a declining population until the mid-1920s. There was a declining population in the new territories. In the mid-1920s, there was a property collapse, mainly in the urban parts, of course, and that went on into the new territories. Still a low population and flat sales. And in the 1930s, of course, there was the slump. So demand was still low because of the bad economy. And because, of course, of the Japanese takeover of Guangdong in 1937. Then in 1941, we have the Second World War, the Japanese occupation, and following the defeat of the Japanese in 1946, military administration. So I think we're safe to say during that 5-year or so period, there were no grants of any type of land. Then in 1946, British administration starts again. They've lost all the documents. They don't know what happened, but the policy was sale by public auction to get the market price, to get income for the government, to make sure there's no corruption. That was the norm. But the Court of Appeal doesn't mention this. The norm was sale by public auction after the Second World War. And private treaty grants were permitted, but only in exceptional cases. And eventually you had to get permission directly from the Executive Council. They were so rare. So there were auctions in the villages during this period. They were village auctions, but they were public auctions. In 1961, Court of Appeal says it's late 1950s. No, it's 1961. There were restricted village auctions. And that went on for over a decade until the small house policy restarts the PTGs. So there were two periods, 1899 or 1901 to 1909 and 1946 or thereabouts to 1960, where there were no private treaty grants. They were not the norm. And there were few private treaty grants during the period 1909 to 1941. Then you had this restricted auctions, but the restricted auctions were auctions and the public could actually get to them despite what the Court of Appeal says. So the Court of Appeal downplays these periods when there were no private treaty grants. And perhaps that's a result of the government evidence, I don't know. And they're also vague about when private treaty grants ceased. They said that private treaty grants continued from 1909 to a few years after World War II, which implies 1950s, but I think 1946. They're vague about when restricted auctions began. As I say, 1950s. Government evidence was they were common in the late 1950s, implying 1958, 59. No, 1961. So there's sale by competitive public auction, which was the government policy, and the likelihood that they were used by once the civil administration was restored in 1946. But what do we mean by restricted, or sometimes they're called closed, village auctions? The practice was to advertise intended land sales in the new territories in the government gazette, on the district office notice board, and in the village or home concerned. And to discourage outsiders, the auction was held in the village, in the hall or the school. And some district officers held them in the early morning. And the district office staff tried to warn off outsiders, warn off townies from buying, because they said that the villagers will be hostile. Nevertheless, the auction was still open to the public, and you did get sales to outsiders. The sale was gazetted until the end of 1960. And so I say they were public auctions, full public auctions until then. And even after that, purchasers could still find out about the auction from the village notice board, but also from the district office notice board. The public was not banned, it was simply discouraged, but you get a different impression from the judgments. So I say it's not accurate to present restricted auctions as private treaty grants. Why do I say that restricted auctions began in 1961, not the late 1950s? Well, the relevant evidence is actually quoted by the trial judge, by Mr. Justice Chow in paragraph 94 of his judgment. It's a memo from the District Commissioner Walton on the 6th of October 1960 to the Colonial Secretary, where he says, I'm experiencing difficulty about the procedures at auctions for village house type lots. In two recent cases, people from outside the village have purchased land for which villagers had applied, so it was open to outsiders. This has prompted criticism by the villagers who resented the intrusion into their community. Naturally, I cannot prevent outsiders from attending and bidding, naturally, because it's a public auction, that's government policy. He then sought approval for minimizing publicity. He said, there's no need for gazetting village type house sales where the upset price doesn't exceed $5,000. So for small, cheap lots, please, can I be excused gazettal? And that was granted on the 11th of October, 1960. So that, I say, is the start of it. Now we're running short of time. Those are my points about restricted auctions. I've already really made the point that there's nothing to do with custom at all. The concern seems to have been to prevent intrusion into villages and maintain public order and avoid difficulties. It was a political thing and nothing to do with custom. That was what Mr. Justice Chow said. And Dennis Bray in his autobiography says some district officers adopted restrictions. So it doesn't seem to have been a universal practice. Now, there's a lot more I'd like to say. The Buildings Ordinance was extended to the new territories from the 1st of January 1961. The Court of Appeal relies on this and says that here you have statutory recognition of the small house policy in legislation. I say no. There's no recognition of ding rights in this ordinance because there's no mention of custom or indigenes. What there is an exemption from the regulations for all small houses, and the well-known dimensions are laid out there. The purpose, as we've seen, was to abolish the distinction between old schedule indigenous house privileges and new grants, making it available to everyone in the new territories. It wasn't a recognition in statute of the small house policy. There's the exemption. They also relied on the joint declaration, Annex 3 on land leases, paragraph 1, all leases are extended. That was really the main purpose, I think, of the joint declaration, is to reassure people about landholding post 30th of June 1997. And that became Article 120 of the Basic Law. They also, the Court of Appeal relied on paragraph 2, particularly relying on this. Government rent shall remain unchanged for rural holdings where property is granted to an indigene for so long as he or his male successors hold the property. That went into Article 122. Briefly, let me make the point. The Court of Appeal said regarding 120, paragraph 1 of Annex 3, all rights in relation to such leases must include indigenous rights, small house grants, or the application for a small house grant. I say no, that's a personal right. It goes with your attributes, your characteristics, the characteristics of the leaseholder. It's nothing to do with the lease. It's not a right in relation to such leases, because a non-indigene has the right as well to a small house grant. So I think the Court of Appeal is exaggerating there. They also dealt with the Convention of Elimination of Discrimination Against Women as part of the interpretation, and the Basic Law drafting materials, really adopting what the judge had said at first instance. And his conclusion was that eventually it had been decided by the drafters, by the drafting committee and the consultative committee, that traditional rights and interests without elaboration would be protected. That's why we don't know what it means, why the courts have been called in to answer. I would point out a couple of omissions in the Court of Appeal's coverage here of the drafting process. First, traditional was inserted during the drafting. So to my mind, that means it must have some meaning, presumably a restricting meaning. Secondly, a special group that was appointed to consider Article 40 concluded that not to alter the wording, but said it could be amended by the future HKSAR government. Well, if that's the case, they must have thought it wouldn't be entrenched in the basic law. The mainland drafters decided to retain Article 40 in the interests of what they call Hong Kong unity. What they meant by that was to keep the CUHK quiet and stop the indigenous from creating trouble. A triumph for Mr. Lawful. There he is, celebrating another triumph. I think it's the 20th time he'd been re-elected as chairman of the CUHK. But his real triumph was getting Article 40 put in the basic law, the article that has caused so much trouble. Well, the Court of Appeal went on to consider as an alternative, their analysis of the case on the basis of tracing, which is what Mr. Justice Chow did. And they not surprisingly, they came to a different conclusion about the private treaty grant from what he concluded. Well, there's a lot more I was intending to say, but time is pressing. So perhaps I can elaborate a bit more if there are any relevant questions. Thank you very much for putting up with me. I hope you could follow it. Sorry about the mistakes in the PowerPoint slides. I'll hand you back to our host.
Thank you very much, Malcolm. It was a very comprehensive study, and I wish we had had more time to go into those other elements, but thank you for covering so much in depth that sort of whole development of, well, what may have become the policy or the reasoning behind the policy as well, and perhaps some points that the Court of Appeal should have considered or should have been made clear to them. Actually, there were a number of questions, but we are really out of time. But maybe just that's one thing is there going to be a follow-up? Is there going to be a further appeal? And I'll pass that back.
Well, I don't know for sure, but there certainly have been developments on that score. There has been an appeal lodged. There was a hearing in the Court of Final Appeal where they allowed the matter to go ahead. The Court of Appeal, despite their ruling, were obliged to concede that there were matters of public interest involved and gave leave to appeal. And the Court of Final Appeal waived the financial requirements. However, one of the appellants, I believe, has dropped out, and the other, Mr. Kwok, he has had difficulty getting legal aid. So maybe it'll be dependent on the outcome of his legal aid appeal. I do hope it does go ahead, because it'll give us certain finality and give the Court of Final Appeal, our best legal brains, a chance to pass judgment on this whole episode and the historical analysis of the Court of Appeal, which I think is somewhat flawed.
Thank you very much. Well, actually, I hope it goes ahead as well, because, of course, that will give us an excuse to invite you back again to talk about that in the future. We are really out of time. We did have a number of questions. I think some people would have liked you to elaborate on why you refer to it as the so-called lease of the new territories, which I think you elaborate in your book. So I recommend them to read your book.
Haven't we got some more time?
We're past the 2 o'clock. We're meant to finish at 2 o'clock.
Oh, I'm sorry.
No, that's okay. Don't worry. We were getting carried away with everything, so time passed very quickly. And I think we may even have had some questions coming from our dean, who's sitting here.
The person who asked that question can find the answer in my book.
That's what I was going to say. Read the book, because it does elaborate about why the new territories lease is not a lease, quite clearly in there. But apart from that, it only remains for me to promote some upcoming events. So if I can ask Connie, my colleague, to tell you that we have some upcoming events at CUHK Law that we'd like you to join in with. On the 20th of September, we have a seminar on the future of corporate governance in capital markets following the COVID-19 crisis by Dr. Yun Tang. And then from CFRED's 16th Legal Tech Seminar, we have Smart Contracts, Technology and Regulation by my colleague, Dr. Elisa Mick. And then finally, probably not so interesting, it's me talking about, in our property law seminar series, well, I'll be talking about non-fungible tokens and digital art. Everyone's talking about them. I'm going to try as well as I can to try and explain what they are, because I've had to try and understand what they are. So I'll try and explain that and what they are and what you get if you buy one, because I think that's an interesting question. That's on the 6th of October. So please join us for these upcoming events. Apart from that, I'd like to say thank you very much to all of you for attending this event. It was very well subscribed and very well attended, because of course we had an excellent speaker. Thank you very much, my colleagues, in particular Connie and the team, for organising everything so expertly as well. Please remember, we have got another Greater China Legal History seminar in October as well, upcoming. And apart from that, just to say thank you very much to our speaker. Is this your third time, Malcolm, with us? Third time speaker, Mr. Malcolm Merry, and we are hoping to have him back to talk more about the unruly new territories, or even his other new project that we didn't get a time to talk about, but there'll be news of that coming out soon. So thank you very much for attending the seminar. We are CUHK Law. Bye-bye.